Good afternoon, everybody. I hope you're doing well and enjoying all the sessions you've attended so far at our expo today. My name is Kerry Chilton. I'm a staff attorney with the Disability Law Center of Virginia. This is a question and answer session, so I do have some questions prepared for us to go over today. On the topic of the session is discipline and discipline rights for students with disabilities. But as you all have questions as we go through the session, feel free to not wait for the end and just type your message in that chat on the sidebar, and I'll be watching that over there. There is a little bit of a lag, so as soon as I get that chat going through from your end, I'll pause and take a minute to answer your questions. As I said, this session this afternoon regards discipline of students with disabilities. And a little disclaimer here before we get started and jump right in. None of the information I am providing today is legal advice. Special education matters are often very fact specific and require review of documents and really talking with a family about what's going on in order to determine what laws may apply and what's the best course of action. So if you have general questions, throw them right at me. I'm more than happy to answer them today. But if you have very specific questions about your child or a child you're working with, that parent should contact our office Monday, Wednesdays, or Fridays and speak to an advocate on duty who can screen that request for services and see if we're able to provide additional assistance. And at the end of my session today, I'll provide you with that contact information and more details on that service. So, discipline of students with disabilities. In both the Individuals with Disabilities Education Act and the Virginia Special Education Regulations, there are special rights afforded to students with disabilities in regards to discipline. Now, I am going to focus in here specifically on students with IEPs or individualized education programs, but some of these rights do also apply to students with 504 plans. But again, the focus today is going to be on students who have IEPs. So the first thing that someone who is new to this area of advocacy or new to this area of rules regarding their child needs to know is that there are two types of removals from school when it comes to disciplinary removals. There are technically three types. So there's in-school removal, and then for the in-school removal, and then the short-term and long-term removal. So in-school removal is going to be things like being sent to a principal's office, being removed from that educational setting. In-school discipline that's not a removal could involve, for younger children, maybe moving down on a behavior chart with a behavior clip, lunch privilege being removed, other privileges being removed, field trip privileges being removed. So that's kind of in school. And then there's out of school, which can be suspension, expulsion. Now, the main thing to know, big difference here regarding discipline and when some of these rights kick in, is short-term removal is 10 school days or less. So you'll note I said school days. So that's when school is in session for students. So that's not going to include a teacher workday. It's not going to include state holidays, weekends. So removal from school, so some sort of suspension, for example, of 5 days is going to be a short-term removal. A long-term removal is a removal for more than 10 school days. Now this can be consecutive. You're suspended for the next 15 school days. You are expelled. Or it can be cumulative. And that's going to be based on a similar pattern of behavior. And that's something that we'll talk about in a little bit. The manifestation determination review team, they're going to decide whether or not multiple instances are a pattern of similar behavior. Similar behavior may be that a student is continually getting into fights with other students, is continually speaking out in class or throwing paper at the teacher. If they're getting suspended for 2 days here, 2 days there, 3 days here, 4 days here. None of them are more than 10 school days, but all these little ones are due to similar types of behavior, pattern of behavior. Then those can be added together to reach that 10-day mark. Now, this is where the importance comes in. Short-term removals, students with disabilities can be suspended the same as their non-disabled peers. They can be suspended. They don't receive any services during that time. Long-term removals trigger what's called a manifestation determination review, which we'll talk about a little bit more in just a second. Now, manifestation determination reviews, this is an area where it's going to apply to both students with individualized education plans and students with 504 plans. There's specific language under Section 504 that courts have interpreted, and it has been interpreted to mean that students with 504 plans also get a right to a manifestation determination review. Now, before we get into all that, the next question that I want to briefly touch on here is, do in-school removals count towards this long-term removal, this more than 10-day count? The regs do not speak specifically to that. The law does not specifically say if your child is pulled out for half a day and is sitting in the principal's office for 5 hours, that's going to be, if it's a similar pattern, add up to those more than 10 days and trigger that manifestation determination review. However, myself and a lot of other advocates would say that is removal from class time. The child is not getting an education, is not accessing the curriculum during that time, and those should be added up. So if it's a half day in the principal's office or in school detention, and that's happening 30 times over the course of the school year, that's going to be more than 10 school days. So once it hits the more than 10 school days, at that point, a parent can advocate and argue that a manifestation determination review should occur. And the other thing that parents often ask about as to whether or not it counts towards that removal is requests to pick up their child from school. So a lot of times schools may call a parent and say, hey, Michael is being really disruptive today. Can you come and pick him up early? Just pick him up early. We're not going to put it in his disciplinary record. Don't have to worry about it. Just come and pick him up. Bring him back in tomorrow. I understand why a parent would not want something in their child's disciplinary record. So I do understand a parent's reason for just picking their child up and having that occur. However, the difficulty with that is an early pickup may not be marked in the child's record, may not be considered as a disciplinary removal, and may not start counting towards that long-term removal. So if a school is saying, hey, we're not going to put it in their record as under a disciplinary incident, just come pick Mike up, early today. And sometimes I find in those situations too, sometimes the school is not noticing that pattern because it's not in the record either. And so those underlying behavioral needs are not really being addressed in the classroom. So parents should consider whether or not they want to say no. If you want me to pick him up early because of discipline or behavior, that needs to be considered, a suspension and recorded as a disciplinary removal before I pick up my child. I'm not just going to pick them up early. So that is something that parents should consider and weigh the pros and cons with. Again, very fact specific, but it's something you may want to consider in order to possibly trigger that manifestation determination review and those rights that go along with that, which we'll be discussing in just a bit. And again, that's also too, if you need to go to dispute resolution later on, it is very clear in your child's educational record, if a hearing officer or somebody else is looking at that record, how many times the child was missing out on educational services due to a behavioral need that resulted in a disciplinary action. If it's not recorded as such in the record, it may be very hard to show to a hearing officer exactly how much instructional time a student missed because of this behavioral need. So, what is this manifestation determination review hearing that we've been talking about? And who is there? So the attendees are going to be any relevant members of the IEP team. That's probably going to be an administrator such as the principal, it may be the student's teacher, things like that, the parent has to be invited to attend the Manifestation Determination Review, or MDR. It has to be held within 10 days of the disciplinary action. So if you are suspended for 15 days, within 10 days of that decision, the MDR has to be held. Or if it's that pattern, as soon as you have that last suspension that triggers more than 10 school days, within 10 days of that decision, the MDR has to be held. Now at the MDR, the school is going to look at two standards to see if either of those two standards are met. The first is whether the school failed to implement or follow the IEP or a behavior intervention plan if the student has one, and that failure led to the behavior. So they're going to look at the circumstances that occurred. They're going to see, was the IEP followed? If the IEP or behavior intervention plan, BIP, was not followed, did that cause the behavior, or is it totally unrelated? So there could be a behavior, the IEP could not be followed. But if the behavior has nothing to do with the service in the IEP, then that's not going to meet that first standard. The second standard is whether the behavior has a direct and substantial relationship to the child's disability. Basically, as the name MDR suggests, is it a manifestation of the disability? Is this behavior a result, a symptom of that disability? Now, important thing to note here, it has to be a disability that the school was on notice of having or suspected to have. So the IEP or the 504 plan is going to outline the disabilities that that plan is supposed to address. There may be other disabilities that generally don't affect the school setting, or maybe the IEP failed to address those other needs related to that other disability. But if the parent has informed the school of that disability and the manifestations of that disability prior to these incidents occurring, then the school's on notice that this is also a disability that may need to be addressed in the school setting. However, if there was an underlying or separate disability that the school was not aware of at all, had no reason to believe that there was this other disability present, then the school is not obligated to be considering whether or not there was a manifestation of that disability, because the school was unaware that that disability existed and thus was not on notice to be able to address that disability before it manifested in behaviors. Now, what happens if either of these standards are met? If there was a failure in following the IEP and that resulted in the behavior, or if this behavior is a manifestation of the disability? The child has to be returned to their placement. So if they were going to be suspended for 45 days, once that decision is made that it was a manifestation, that one of these standards was met, they have to go back into the school setting, unless the parent and the school agree that another setting is more appropriate. So if the parent and the school both agree, this placement is not working, indicated by these incidents or indicated by something else, let's try putting the child into this program or this classroom, parent and school can agree together to do that. But otherwise, the student is returned to that placement, that educational placement setting they were in prior to the school removal. If neither standard is met, the child can be suspended or expelled or complete that removal. However, we'll talk about in a little more detail in just a bit, special education students do have to receive services during that long-term removal. During short-term removals, they don't have to receive educational services. So if they're suspended for a day, they don't have to be receiving services during that day. The long-term removal is different. We'll talk about that more in just a minute. I'm not seeing any questions here yet, but I'll keep my eye out in the chat bar if any pop up. So moving along here, what are some tips for a parent to advocate for their child at an MDR hearing? First of all, in advance of the MDR meeting or MDR hearing, request that the discipline packet, including any incident reports, be provided to you. So that's going to include those reports, that's going to include recommendations, other relevant information the team's relying on in making their decision to do that disciplinary action. That disciplinary packet is really important because that helps you get a better picture of what the school is looking at and considering and making their decision. Now, this is a very quick timeline. Remember, within 10 days of making that disciplinary decision, they have to hold this hearing. So right away, as soon as you get that notice, you want to immediately be requesting from the school that that disciplinary packet be provided to you in advance of the manifestation, determination, and review, and as soon as possible. That's really important. Then you want to look through that. As I talked about in some of my earlier sessions today, if any of you were sitting in, you probably want to make a clean copy and a markup copy of that. So you have a clean copy if you need to make more copies to give to people, and a copy that you want to mark up to say, you know, this is not factually accurate, or my student reports a different event. Yes, my student does this because of his PTSD, like note in the margin, any questions, you want to, you know, have a copy to be able to mark up. If possible, you may want to bring in an outside provider that can speak to the manifestation of your child's disability. If your child has a therapist that can explain that, yes, this behavior is related to the disability and here's why. If a provider isn't able to come in person or call in to testify live or, you know, provide information live, you may want to ask the therapist to draft a letter. If there's pertinent medical information or records that speak to how their disability manifests, you may want to submit some of those records to the school again in advance. So the school has a chance to review those prior to that manifestation determination review hearing, if that's possible. But if not, bring it to the meeting, talk about it. To the extent that you can have professional records or testimony information that relates to how your child's disability relates to that behavior, that can be very helpful. What does your child's other educational records, IEP, state about the manifestation of your child's disability? So in the plop, in that, you know, summary of your child and their needs and strengths and weaknesses in those IEPs, is there an IEP from last year that really talks in detail about this same behavior that is the focus of the manifestation, determination, review, and this removal? Is there other documents? Are there evaluations that talk about the same behavior and link it to the disability? Really be reviewing those documents to see. This is almost in ways, you know, any professionals out there who have done any sort of advocacy or who may be attorneys who are on this session today, it's similar to preparing for a hearing. You want to, you know, your argument is that this is linked, you know, that this is a manifestation of your child's disability or the student you're working with disability. And to the extent that you have information in the record, information that you can include and provide to the school that shows that and supports that, you want to have that prepared ahead of time. And again, we're working on a really tight timeline here, but to the extent that you can prepare these things, it can really make a difference. 1 second here, let me make sure I'm not skipping over any important information that I jotted down in my own checklist. One of my earlier sessions today, I talked about the importance of checklists to make sure you're not skipping over anything. And again, so in addition to looking to see if a provider can write a letter, making sure you're looking through your child's medical reports or therapy reports as they're pertinent to this incident, to see what other information you can use to support your child at the manifestation determination review. So next question. Does a special education student receive education while they are suspended? I told you we would touch upon that, and here we are now. So short-term removal, as I said, a student with a disability is disciplined for short-term removals the same way that students without disabilities are. They don't receive services during short-term removals. Different for long-term removals. So for long-term removals, the school has to provide services so that a child is able to continue to participate in the general education curriculum and receive services to continue to work on IEP goals. So during that long-term removal, the school has to provide services that is allowing the child to progress in that curriculum and also work on their IEP goals. So, tricky thing here. As we talked about earlier, sometimes that long-term removal comes to be by a series of short-term removals that add up to more than 10 school days from a similar pattern of behavior among all those removals. Oftentimes it takes several days, sometimes a couple of weeks for schools to set up services in an alternative setting while a child is suspended. And if you're only suspended for 3 days, those services may not be able to be put in place before the child's returning to school. So this is tricky when you've got those 3-day suspension, 3-day suspension, 3-day suspension, 4-day suspension that are creating a long-term suspension, which is entitling a student to those continued services. Now, an approach that parents or advocates can take here is there is something called compensatory services. Again, students are supposed to receive a free and appropriate public education. So a parent or advocate can put forth the argument that, well, look how many times they've been removed. And here's a detailed explanation of how all these removals have slowed down this child's access to the curriculum, how they're behind and otherwise wouldn't be, how it's affecting their ability to access the curriculum. And I understand that they're short-term removals and we can't get a teacher in when it's only a 1-day removal, but we need to do tutoring after school, or we need this child to be to have an aide or additional staff to student ratio to be able to attend to the student a little more, to try to help them focus more, to work on getting back to where they should have been if they weren't removed so many times. So there are ways to ask for alternative services if you're not able to get those services in place because it's these pattern of short-term removals that are constituting a long-term removal. A lot of times when it is a long-term removal, that's a consecutive one, so it's that 45-day suspension or something like that. Most schools will provide what's called home-based services. And again, all this is a little different in the time of COVID as to the practicalities of exactly how these things may be provided, but the general concepts are going to still apply. And when we return to in-person, school and in-person home-based services, this will apply still at that time. Home-based services or when a teacher comes, sometimes to a public library, sometimes to the child's home, to teach the student one-on-one, to be able to continue that school's obligation to allow the child to participate in the curriculum and work on their IEP. Now, the question here that a lot of times schools and families have to work out and figure out is, well, how many hours of services for home-based services should my child receive? And some parents ask, is there a maximum amount of services that a child can get on that home-based service provision? The answer is no. So the Virginia Department of Education, the regulations don't say, students can only receive up to 10 hours a week of home-based services. Also, schools shouldn't be saying, well, we only provide up to 5 hours and that's all we ever provide for a student for home-based. You get, 5 hours to 2.5 hour sessions a week, and that's just our policy. Again, the IDEA, the first letter there is individualized, right? So the decision of how many hours of home-based services a child should be getting while they're on a long-term removal should be based on what is required to provide a free, appropriate public education to that student, what is required to allow that student to continue to participate in that general education curriculum, and continue to work on their IEP goals. I mean, you can look at that IEP, well, where were we supposed to progress to by the end of the year? Well, we should be moving kind of at this rate. Are we moving at that rate? Do we need more hours to be able to keep that child progressing and on track? Because the worst thing you want is to have a student to be returned to the education setting after a long-term removal and be so far behind that they're really being placed in a situation that may even trigger more behaviors, right? Because they're behind, they're struggling. And again, there's that obligation of schools to provide services to students with disabilities while they're long-term removed. So that should be an individualized IEP team decision as to how many hours of home-based services the student needs. And parents are a member of the IEP team, so parental input is important in those conversations as well. So we've had a manifestation determination review. Another thing that manifestation or termination review hearings are used for is to determine if there's a pattern of behavior, if that behavior is similar enough to constitute a pattern. So just side note there. What happens if you have one of these hearings and you disagree with the outcome? You think that this was a manifestation of your child's disability, that the school said it wasn't, or you believe that the school didn't follow the IEP, or that something is a pattern when the school determined it wasn't. You have a right to file for due process if you disagree with that school's decision regarding whether or not a series of behaviors is a pattern to constitute a long-term removal, or whether or not the behavior is a manifestation, and it's expedited due process. So the timeline for that, from requesting due process to having a due process hearing, is maybe a matter of a few weeks, a little over a month, versus regular due process timeline. It can be, more a couple months or so to really get to that decision. The concept there is that students are out of school completely while they are receiving some home-based services, possibly, or some other type of services. We want to get that decision made quickly to get the child back in school if it's determined that that should be the case. Due process, for those of you who are unfamiliar with it, is similar to a more informal trial. So the school and the parent can both bring witnesses, ask them questions. The other side can ask them what's called direct questioning and cross-questioning. You can put on evidentiary documents. You can submit evidence. Each side is going to argue their position, and the hearing officer is going to make a decision that is binding as to who is right and if certain remedies have to be made if there was any harm to the child due to a failure for the school to follow their obligations under the law. Because of this, it can be very complicated. The process is complicated. The timelines are complicated. The school's going to be represented by their attorney. For these reasons, we really recommend that parents are going to be working with an advocate or an attorney as well to make sure they understand that process. And it looks like we have a question right here that says, during that time, does a BCABA come and do observations to determine the patterns? So that's a really good question. And it also touches upon something as well that I haven't thrown in here yet because we have a very short session today. So this is kind of a condensed, version here. So a BCBA, or some sort of behavior specialist from the school, if there is reoccurring behaviors that are impacting and affecting that student's learning or the learning of others, there should be an IEP team meeting to discuss potential interventions. If it's continuing and those interventions have not worked with that behavior, a behavior specialist should be brought in, and functional behavioral assessment should be considered, where someone with that knowledge of how to collect behavior data is maybe sitting in on the class, talking to the parent, talking to the teacher, collecting that data and making a formal assessment as to what the cause of that behavior may be. And that could be a whole session on its own. But that should be considered. And schools do have a responsibility to proactively, before all this discipline happens, one second, gotta move here, take some of those steps. So yes, and if a manifestation, also too, important side note here, at a manifestation determination review, if they find that either of those two standards are met to constitute a manifestation of the disability, then an FBA, that functional behavioral assessment, and a behavior intervention plan, which is a plan of strategies to address the behavior based on the data collected in that assessment, have to be conducted, or if one's already been conducted on that behavior, that behavioral assessment and behavior intervention plan needs to be reviewed and updated. So if the team finds that there is a manifestation of the disability, they need to be conducting that FBA and that BIP. Exactly right, Jennifer. And again, that should be a proactive thing too, if the school is identifying a need for that and the team is identifying a need for that prior to this discipline action even occurring. Let me take a look here. We are just about out of time. As I said, due process, you have a right to file due process if you disagree, but you should be consulting with an attorney or advocate who can help you make that decision and go through that process if you're pursuing that. There may also be an internal appeal with the school division within the school division for appealing those long-term suspensions, expulsions, MDRs. So that's something to be aware of as well. We won't go into detail of that today, but something you should definitely be aware of your rights to dispute or appeal those decisions. So again, the last thing I was going to talk about was those FBAs and those BIPs. If you disagree with the functional behavioral assessment that was done by the school, you also have a right to request for the school to pay for an independent educational evaluation where you can bring in your own specialist and have a separate FBA conducted, again, paid for by the school, but with an outside provider. So we are out of time today. I'm going to quickly give you the information on accessing our advocate on duty. As I said, they're available Mondays, Wednesdays, and Fridays from 8:30 to 4 p.m. And you can call 1-800-552-3962, which is toll free, or 804-225-2042 to request assistance or complete an online request for services. Our phone numbers are also available online. If you don't speak English, we have what's called a language line where we can get connected to interpreters for a wide variety of languages to be able to communicate with you through that interpreter in your language. So that is a service we have accessible to us and our callers as well. I hope you all were able to take away something, learn something new from our session today. There's a lot more to learn about discipline. We have a little video on our website on our special education page that talks a little bit about some discipline rules and things like that if you want to take a look at that. But I hope today, you learned something new. Thank you, and I hope you enjoy the rest of the expo.